Ronald Bartsch Jr. versus Premier Orthopaedics and Sports Medicine, PLC.
We'll hear from the appellant.
Good morning, Your Honor. Justices, my name is Clint Kelly. I'm with the Sumner County Bar. We respectfully request that Your Honor reverse the judgment of dismissal. It was a Rule 20.026 dismissal for a simple reason. The trial judge violated the standards
Mr. Kelly, sorry to interrupt you. Would you like to reserve any time for rebuttal?
Thank you, Judge. I'd like to reserve 3 minutes.
3 minutes.
It's been a
Very
while.
good.
The trial judge violated the standards applicable to Rule 12.026 when the trial judge accepted evidence in its decision, which were exhibits filed to a reply to the motion to dismiss, to conclude as a matter of law that Mr. Bartsch knew or should have known on April 27, 2022, corporate data that was printed from a website from the state of Tennessee on May 15, 2024. And that this identical information, which by the way is not authenticated, has no seal on it, that this information was available to Mr. Bartsch, and had he known of this information, he would have concluded, or a reasonable person would have concluded, that the true defendant in this case was not Houston Clinic Orthopedics Southeast PC, but rather Premier Orthopedics and Sports Medicine, which was doing business under an assumed name.
Counsel, is the problem the document or is the inference from the document?
It's the inference, Your Honor, basically.
Okay, so even if the court was to say the documents were fair game, the problem is the inference that this was the same route that you could access this information 2 years earlier, in that earlier time period, and that would require testimony and evidence that's not.
Precisely, Judge. I can go into a lot of other efforts here, but you have hit the nail on the head. This was an improper use of inference that benefited Premier, not Mr. Bartsch, which is a complete violation of the standard applicable to Rule 12.026. And, Your Honor, I raised this with the judge during the hearing. I mentioned it in my brief. We had a very heated argument, so to speak, over it, respectful but heated. And I informed the judge, I said, you are making a leap of faith here, inferring information that's in this document was A, available to Mr. Bartsch, and B, Your Honor, that he could take that information and conclude as a matter of law, or reasonably conclude, this was the right defendant to sue. And I pleaded with the judge, look, we can take this up at summary judgment when there's a record developed. Maybe we take it up a directed verdict if it gets to a jury, but this is the wrong procedural vehicle to make this decision.
Well, I want to make sure that I'm clear on your position here. In response to Judge Usman's question, you said it's not the document itself the problem, so you think that the court properly could consider the printout as part of a 1202 motion. That was completely legitimate in a case like this.
No, sir, and I probably misspoke. What I thought the justice was asking me was the real problem here is the inference. I take issue with the document itself because it's not authenticated, Judge. I mean, my understanding of Rule 12.026 is you don't take an exhibit and use it to decide the pleadings issue that is disputed, which it was, highly disputed, and not authenticated. That's the problem we have here. But I think the key issue, the overarching issue, is what the justice said. She inferred information from this document that she never should have. We can argue about judicial notice and whether it was improper or not, but it's the inferences that really trouble us because she made a value judgment. He should have known certain things, and those benefited the defendant.
Returning to Judge McRae's question, you see this as two hurdles. You essentially say they trip over the first hurdle in terms of they shouldn't have considered the document at all, and even if the document's okay, they trip over the second hurdle in terms of the inference.
That's correct, Your Honor, because she made numerous inferences. It wasn't just inferring that he could have found the proper defendant. She also inferred that this data was available to Mr. Bartsch in April of 2022. She made that inference for them as well. She made an inference that had he looked at Houston Clinic Orthopaedics PC, that he would have concluded from all of these business entities right here, he would have pinned the tail on the donkey the right way the first time. One other thing, Your Honor, I don't want to let dust grow on this one. She did not consider at all what we pled in our complaint, which was the defendant did not, or the party who received pre-suit notice, which was Dr. Burleson, the surgeon, did not identify Premier Orthopedics and Sports Medicine pursuant to its duty under 2926-121, Section A5. This is now the third time, Your Honor, a litigant has come to this court or to the Supreme Court and has not been informed because a defendant healthcare provider refused or failed to identify another party that was at fault. Judge Kirby, in her concurrence, like a prophet, said, this statute, if we don't put some teeth into it, is going to serve as a perverse mandate for defense counsel not to identify.
So you're not inviting us to do what Bidwell did not do, is to put some teeth in the statute, are you?
Nope. In fact, I'm doing something different. I'm asking Your Honor to decide as a matter of discovery, not penalty, but discovery, that if you fail to identify the proper party, that is a factor that can be used by the plaintiff to establish that the plaintiff didn't know who the proper defendant was. In other words, it's part of the discovery process. And therefore, our position is the statute remained told as to the proper identity of the tortfeasor because, in part, Dr. Burleson did not, and as well, Houston Clinic Southeast PC did not identify the proper party. That's undisputed. They do not dispute that they didn't identify that
Counselor,
party.
isn't your client aware as of, in April 2023, there's a document here, right, that lists Burleson's employer as the correct entity. So I found out somehow who this correct entity was, at least as of April 2023. Or am I misunderstanding the record? Isn't there a letter in here that has the correct employer listed there?
Judge, there is. The problem is we're having to go on the pleadings. That's ultimately the issue here. Mr. Bartsch's position is, I did not know who the proper defendant was until the answer was filed and amended, the answer filed in federal court identifying Premier Orthopedics, that he did not know. We're limited here to the universe of the pleadings, not what we think he should have done based on records that were submitted earlier. Our position is, once that answer was filed, the tolling stopped. Mr. Bartsch was notified at that moment who the proper defendant was. He gave pre-suit notice within the year and sued properly.
Was the pre-suit notice proper here? And it only authorizes information to be shared with counsel, right? And is that a valid pre-suit notice?
I'm sorry, I don't understand the question.
So the pre-suit notice that's provided here in terms of sharing documents, right? One of the ideas is that the potential tortfeasors can share information among themselves. But did this pre-suit notice actually authorize that?
The one in federal court did not. There's no question. We don't dispute that the HIPAA form was defective. But the fact is, Dr. Burleson got the pre-suit notice. He knew who was receiving the pre-suit notice, and he knew that Premier Orthopedics was not identified. And based on the statute, he had a duty at that moment to notify us, notify the plaintiff, that Premier Orthopedics and Sports Medicine was a potential defendant. It was his employer. Again, either 2926-121 Section A5 means something or it means nothing. And this court, by the way, in Gardner, which involved the same defense counsel, I might add, Judge Bennett said that just because there's no penalty in the statute does not mean that it doesn't have substance, does not mean that it cannot be used for some purpose. In this case, we contend the purpose should be used to establish that Mr. Bartsch did not discover who the proper defendant was because he wasn't notified, pursuant to this statutory mechanism.
Let me ask you a question. I understand you have issue with the document which the court took judicial notice of, but it looks like from the trial court's order, and I'm looking at page 5 of the trial court's order, that the trial court made an alternative finding and said essentially in the alternative, regardless of whether the court took judicial notice of the exhibits attached to the defendant's reply, in reviewing the collective exhibit attached, Exhibit A attached, the court finds there is sufficient information contained in that exhibit to demonstrate that an objective person would be put on notice to have performed due diligence and his or her duty to investigate to find further information regarding Dr. Burleson and Houston Clinic Orthopaedics. So are you considering that to not be an alternative finding?
I think that gets back to Judge Usman's previous point, which was to come to that finding, she had to infer in favor of Premier that Mr. Bartsch could make this finding, Judge. She had to decide that there were things Mr. Bartsch could do or should have done and inferred he could make conclusions that favored Premier. That's the problem we have here. Let's remember, Mr. Bartsch pled in his complaint. He reasonably believed that Houston Clinic Southeast PC was the proper defendant. He pled that. And so what she's done is she's saying, I'm not accepting that as true, Mr. Bartsch. I'm going to infer based on this record that you knew or should have known that this group was practicing under an assumed name and you should have made that decision on your own. It was unreasonable.
So if I'm understanding your response to my question, it sounds like you take issue with this alternative finding.
I do.
But is that actually included within the issue that you've raised here on appeal?
Well, the issue I've raised on appeal is, first of all, that the court should not have taken these documents into consideration. But I also argued that the court made inferences that it should not have made to conclude that Mr. Bartsch should have known that Premier Orthopaedics was the proper defendant. That's what I did. And I also mentioned, Your Honor, that one of the mistakes she made was she never considered the fact that the defendant did not identify Premier Orthopaedics in the pre-suit notice as it was required by statute to do, nor did the judge consider that, Your Honor, when she entered her order. There's not one word in her order, you've read it now, not one word in there about the fact that there was no identification of Premier Orthopaedics and that the statute was violated, which, by the way, Mr. Bartsch pled that in his complaint as well. So yes, we raised the issue, wrong inference, wrong documents, and failure to take into account that the statute was violated and that that was one of the reasons he didn't identify Premier.
Well, Mr. Kelly, I think our confusion comes in with the fact that in your brief, the statement of issue differs from what is actually argued in your brief. If you look at your statement of issue, you say, did the trial court err in dismissing the case based on the statute of limitations when it took judicial notice of documents with data printed from state websites to include Mr. Bartsch's head inquiry notice of the tortfeeder's identity? So that, to me, I read that at first and I thought, okay, we're talking about judicial notice here. But then if you get into the body of your argument section, I mean, it never really matches up with that issue. It has separate. So you can see our confusion because you've departed from your statement of issue in your argument section, have you not?
If you look at number 2 of my summary of argument, which is how I have this thing laid out, the second argument involves the statute, all right? And also, if you look at the notice that I sent to the court, where we're supposed to give you all some idea of the issues we're going to raise on appeal, it's in that document as well where I raised this issue. And if you'll note, several times in the brief, I'm arguing that the court misused the inferences, violated Webb, violated Red Wing, to conclude Mr. Bartsch knew something that actually an inference that benefited Premier, not Mr. Bartsch. So, I mean, the overarching issue, Judge, the overarching issue is Rule 12.026, the standards of applicable that were violated. That's the overarching issue. A sub-issue is you didn't consider the fact that pre-suit notice statute was violated. You inferred facts in favor of Premier, not in favor of Mr. Bartsch, and you took documents into consideration you never should have because they were not authenticated and they weren't proper evidence to consider. And then you had to infer from these documents Mr. Bartsch had to come to conclusions, and you never proved Mr. Bartsch would have come to these conclusions because these documents
Mr.
never
Kelly,
proved.
you've exceeded
I
your
know I
time,
have, Judge.
so
I could go on and on about this, I'm sorry.
Your Honor, may I say something? I'm Mr. Bartsch.
Mr. Bartsch,
Uh,
Mr. Bartsch. No, can't do that here. Sorry.
Right. Thank you, Mr. Kelly. We'll hear from you on rebuttal.
Thank you.
May it please the court, my name is Nate Gorman. I represent the defendant in this matter, Premier Orthopaedics and Sports Medicine, PLLC. I think actually, let me back up, PLC. Despite what you heard from plaintiff's counsel, at the heart of this matter, this issues on appeal are really deficient pre-suit notice that happened in the initial set of letters that were filed, and a statute of limitations and discovery rule issue. This is not an issue of 29, 26, 121A5, whether or not other non-parties were supposed to give notice, but I'll be happy to argue that as well. Judge McBrayer, I think you kind of hit this on the head, is there's an issue raised on appeal about this being about judicial notice and the standards for Rule 12.06 or 12.026 motion to dismiss, but there's just a number of things that are just thrown at the wall to see what sticks. And I think that's what I understood your comments to be. I think it may be helpful. I know you all have read all the briefs. I know you've seen what we've laid out as the factual allegations. But this has a somewhat interesting procedural history.
Because we started in federal court.
Yes, Your Honor. We started in
Or at
federal
least your
court.
client did not start in federal court.
My
This case
client did not start in federal court. That's correct. This case and the claims that were filed started in federal court. But really, it all starts with a pre-suit notice letter. That pre-suit notice letter was sent back in April of 2023. It identified Dr. Burleson. There are two separate addresses on those letters. Those are, I don't have the exact page number because part of this was placed under seal, but as far as the trial record or the technical record, Section 5 that was placed under seal, has Exhibit A that was filed to the complaint in state court, which was the pre-suit notice letters issued in April of 2023. Those include Stonecrest Medical Center, but it's not just this is Stonecrest Medical Center. It is whatever HCA entity doing business as Stonecrest Medical Center. Has two addresses for Dr. Burleson. Judge Usman, you hit the nail on the head there. There's one that says Dr. Burleson at Houston Clinic Orthopaedics. That's clearly there. That's showing, and that's on the pre-suit notice letter.
Counsel, there's an email response after the pre-suit notice is sent in this case. If I recall it correctly, there's a response from counsel, I believe with your firm, and correct me if I'm misunderstanding or misremembering here, that says something like, I represent Burleson and Houston Clinic. And that's sent back to the other side in terms of continuing communication in this case. I'm wondering about that response in terms of a response saying I represent Burleson. I think makes perfect sense given part of the position that's being said here. But why is the email saying Houston Clinic if Houston Clinic is not yet on notice of a case against them? I find it intriguing that email says both of them.
And I understand your question. As far as why it was sent back, I think the reason there was any kind of correspondence at all is because there was a deficient HIPAA authorization that didn't permit release to anybody identified.
Why does the email include Houston Clinic though? And if Houston Clinic's not getting any kind of, and if this is a ridiculous confusion by the opposing counsel, what's the attorney doing but writing back saying represent Burleson and Houston Clinic?
Your Honor, I think obviously that they represent Dr. Burleson. I think that's clear that he would have been represented had a suit been filed that named him. And because this was in a pre-suit notice period, as far as just representing back, hey, I represent Houston Clinic, I don't have a good answer for you, Your Honor. Okay. The better way to say this, I may not have a good answer for you based on there may be different corporate entities here. At issue is the DBA of Houston Clinic Orthopaedics, which is part of the issue with the judicial notice that I'll get into here in just a little bit. But as I was saying, there was pre-suit notice sent. It was deficient. I think one of the things I heard plaintiffs or opposing counsel say is, well, there's supposed to be teeth to these statutes, and because somebody didn't notify us that there was another entity, I think that if we're going to argue anything about the duties of other parties that are not before the court today and that weren't sued in state court, I think the issue has to be is first there has to be compliant pre-suit notice. And that includes a compliant HIPAA authorization so that people can actually investigate to see if there are other parties out there. You know, for all these other people know, who knows who employs anybody? It's not identified in the pre-suit notice. There's not a valid HIPAA authorization. There's not ability to investigate from any side of the defendants. But that's really not the issue before the court today. The issue before the court is whether or not there are sufficient facts available that a reasonable person should have discovered Premier Orthopaedics and Sports Medicine.
So on so taking the two separate bases that the court relied on here for the dismissal, the one of them, the additional submissions that were made with the motion to dismiss, I mean, wouldn't the appropriate way to have handled this would be to go to the Secretary of State and get a certified copy of the annual report that shows where the assumed name was? I mean, isn't that the right way to present this? I'm a little worried about relying on print off from the internet. Is my concern here.
Well, I understand that, Your Honor, but this is a print off from a government source. It is something the Secretary of State maintains for the public to use and identify these parties. This would be no different than, say you had a car wreck down the street and there was a name on the side of the truck and someone wanted to look up and see what the corporate entity was before they sued it. Well, how does the general public go get that information? It doesn't have to be just the general public. How do other attorneys get that information to initiate a lawsuit against somebody else or another corporate entity?
So
you look up the name.
That makes this internet source different from all others.
Yes, Your Honor. It's not something where I'm going and saying, here, we're just going to Google this and we're going to see what pops up if I put in Houston Clinic Orthopaedics into a search function on Google. It is, let's go to the Secretary of State's website and put this name in and do its business entity search, which you have to do in order to figure out what the corporate entity is behind it, which is...
So if I can get, and I'm sorry to interrupt there, but if I can get past that issue and maybe go to the secondary issue, this secondary argument is, well, somehow the collective Exhibit A submitted to the original complaint would have been enough to suggest that this plaintiff could have determined who the doctor was actually working through. Can you step me through how that analysis works? Is that based on the address of the letter, or is that based on the defective HIPAA notice, or how do you follow from those documents, collective Exhibit A specifically,
to the complaint?
Yeah, right.
Well, I think first, we start with Rule 10, and we start with the case law saying that an exhibit to a complaint is a part of the complaint for all purposes. And so I know that's maybe very elementary, but I feel like that's where we start first, so it's part of anything that can be considered. The next part is when we look at these pre-suit notice letters, and again, those are part of the technical record at 5, it identifies the Houston Clinic Southeast PC, it identifies Dr. Burleson, and it identifies HCA Health Services of Tennessee, Inc., doing business as Stonecrest Medical Center. For one of the addresses for Dr. Burleson, it is Houston Clinic Orthopaedics, PC, 300 Stonecrest Boulevard, Smyrna, Tennessee, 37167.
And so is it the fact then that when using those separate addresses, it didn't add the word Southeast under the doctor's name there that suggests that, hey, we knew it different? Is that where it comes from?
Yes, Your Honor.
Okay.
It's Houston Clinic Orthopaedics. That is the DBA, and that information, and that's part of what when we look at some of the judicial notice. When someone's going to go and sue a healthcare provider, they have to send pre-suit notice. Y'all are very familiar with that. You deal with it, I'm sure, numerous times here at the appellate level. But they have to look up for an individual provider their practice address on the Tennessee Department of Health's website. Again, that is another website that's maintained by the state that provides public information that anybody in the public can look up. And that is where that information comes from. And that's what we use for the judicial notice to further establish. But those are all acceptable areas of information to draw from. And again, it's appropriate to consider matters subject to judicial notice in ruling on a motion to dismiss without converting it to a motion for summary judgment. And we've set that out. That's something that is the Tennessee case law has looked at numerous times. One of the other things I kind of wanted to wade into a little bit as well, why I have the mic, is one of the arguments I heard from opposing counsel was I pled the discovery. I pled that my client couldn't reasonably discover this corporate entity, and I pled that, and therefore that has to be given, has to be accepted as true. First, that's a legal conclusion, which we've set out. The trial court doesn't have to accept allegations that are nothing more than legal conclusions or legal arguments as true in evaluating a motion to dismiss. Second, this court, and Judge McBrayer, I think I was here before you previously. Actually, I wasn't here. I think we were during COVID times, but I was across the screen from you in the Carr case, which we've cited. And there are similar allegations in that case where the plaintiff pled that by a date certain they couldn't have discovered that they had claims against the hospital, but they did know of an injury by a date certain. And I'm sorry to say date certain so many times right there, but I think the better way to say it is they knew of an injury in October, say for example, 2020, but they didn't think that they had a claim until sometime in May of 2021 against the hospital defendants. And the trial court, which was when Judge Gayden was on the bench, found that the discovery rule still applied despite those allegations and barred the claims. And that was affirmed by this court, and I remember arguing it in front of Your Honor previously. And so this argument that I can have legal allegations or legal conclusions and those have to be accepted by the true and ruling on a motion to dismiss are not borne out by the case law and not borne out by other Tennessee cases addressing the discovery rule. I think there's a great quote. I say great. There is a great quote in there. Whether or not I can read it perfectly or I just have to simply paraphrase. And it's from the Grindstaff case. Make sure I have that correctly. Which was an unreported Court of Appeals opinion, and it addressed whether or not a plaintiff could discover the principle of the agent driver of a vehicle, I think is maybe the best way to state it. But they basically went into this, and I'm going to paraphrase it, that a lack of due diligence by the plaintiff, it doesn't allow them to simply just plead around the statute of limitations by claiming that they didn't know or they couldn't discover it. You know, that's not enough to essentially apply the discovery rule here. As far as, I think one of the things, I'm sorry if I keep hitting the microphone, Judge McGee, I think you also hit this. There was an alternative ruling. I would say that the alternative ruling, if the court finds that there's an issue with the judicial notice and how Judge Ingram applied judicial notice and taking notice of certain facts and granting the motion to dismiss, I do think the alternative finding should equally apply here. I believe that this court's review is de novo, and if there's an alternative basis for affirming the motion to dismiss, I would urge this court to take it should they have issues with the initial or principal ruling. Are there any questions for me?
All right. Thank you, Ms. Gorman.
Okay. I appreciate it. Thank you all for your time.
Mr. Kelly, we'll hear from you on rebuttal.
So if I'm understanding the defendant's position, because the address for the doctor is Houston Clinic Orthopaedics PC, that means he has to know at that moment that it is a entity that's doing business as, or rather being done business as, Premier Orthopedics and Sports Medicine, and there's no document in the record proving that. The only document that was submitted is this. So what the court's done is the court has inferred he's supposed to know that Houston Clinic Orthopedics PC is doing business under another name, but she's using documents that are unauthenticated to make that decision. That's the problem that we have.
Counsel, is the net effect of your argument to essentially eliminate a motion to dismiss in this context if an employer is not listed? So if I go in, I have a medical negligence action, I know who my doctor is, but I didn't list the employer, that can't be a basis for dismissal, because we're going to have to get facts. We're going to have to get to summary judgment in every one of those cases, because I've got to get facts to know, to prove that that person knew it or should have known it. We can't draw from the, it operates under a particular name, and it can be determined. appropriately by the party suing. Are we nullifying motions to dismiss if we embrace your argument? How is your case different than any other case where somebody doesn't name the employer?
Well, in this case, because there's multiple entities, multiple businesses that had the same name. Secondly, I don't understand why Judge McBrayer's solution that wasn't the right one, which is what I suggest to the judge. Why not get a certificate from the Secretary of State indicating this data that's listed from a website is the accurate data? Then the judge doesn't have to guess, doesn't have to make a leap of faith here about what's right. So no, Judge, I actually think you can do this at Rule 12.026, but you have to do it right. Respectfully, they're good lawyers over there. They could have fixed this very easily by going to the Secretary of State, printing this out, putting it together, and then at least arguing there's data in the chart or data in the record for finding that Mr. Bartsch could have put the dots together to decide who the right defendant is. They didn't do that. They just printed stuff off the internet, slapped it onto a pleading, sent it to the judge, and said, you get it right. That's not the way you do it at 12.026. One other thing I want to add, they did admit in their brief, because I think there's been some misunderstanding, Mr. Bartsch did do an investigation in this case. He did try to figure out who the right defendant was. They admit that in their opposing brief. So this wasn't like he just slapped a name out there, came up with a name, and didn't do any investigation. He did. Then he sends pre-suit notice, doesn't get another name, and thinks, I've got the right guy. Right. At the end of the day, this comes down to reasonableness under inquiry notice. There was a fact issue here. This was the wrong place to decide it. Thank you.
All right. Thank you, Mr. Kelly.
Yes, sir.
The case is submitted. Thank counsel for both sides.